Hello and welcome back to the Adam Bernard podcast. My name is Daniela. I'm your host. I'm joined by an expert in immigration matters, Mr. Bilal. How are you today?
I'm fine.
We're going to be talking about something very important, Mr. Bilal. Anyone that's wishing to settle in the UK, and it's known as indefinite leave to remain.
Yes.
I have a couple of questions for you, what the recent changes are, and the biggest questions that people are asking today. What exactly is indefinite leave to remain, Mr. Bilal?
Well, indefinite leave to remain means if a person is on leave in the UK and he is subject to immigration control, he or she is subject to immigration control, and he has to extend his visa after that or before the expiry of that particular leave. However, if somebody has indefinite leave to remain, it means the person can stay here without any time limit. So this is a technicality or used in immigration law. If somebody has indefinite leave to remain, he or she is not subject to any immigration control. He or she can live here indefinitely, and he has not or she has not to seek any further extension of stay.
Okay. What is the difference between ILR and permanent residency?
Well, this is generically more or less same synonymous terms. However, as a student of immigration, there is a difference between indefinite leave to remain and permanent residency. While we are talking about British immigration rules, we will say if somebody settled here permanently, it means he has indefinite leave to remain or she has indefinite leave to remain. However, if somebody has a permanent residency, this is under immigration rules, which are European Union or EU regulations. If somebody has a permanent residency, it means he or she has been dealt by EU immigration rules, or you can say that European Union rules. Since somebody has been granted permanent residency under EU regulations, that person is subject to exercise treaty rights for 5 years. So what are treaty rights? Well, exercising treaty rights mean if somebody is from European Union, like all those 28, 29 countries, the person has to be in the UK, first of all. Secondly, he or she has been exercising treaty rights. Either they are in full-time employment or self-employed or in education or seeking benefits or recourse to public funds. Or he or she is a person who is having independent means, like he or she has pension coming in or independent income. So these are 5 clauses or 5 heads. It means that the person has been exercising treaty rights. Either of all these 5, if he or she is exercising those rights, it means he or she has fulfilled a condition towards PR or permanent residence. So, having said so, generically, PR or ILR, more or less having the same functionalities here. And once a person has been granted PR or ILR, the person has to stay in the UK for a certain period of time. And if somebody leaves UK for more than 2 years, on the way back, the person will not be admitted directly. It's a discretion of Secretary of State to grant entry. But the person has to apply new entry application. Mm-hmm. And further to that, since those people who are living in the UK on permanent residency, they are from European Union, and if their cases have been disposed of, and since UK is outside European Union at the moment, since December 2020, so there's no longer PRs available because that term is used under European regulations.
Thank you, Mr. Okay, the next question I'm going to ask you may seem generic, but I have had a lot of people call me and ask about this question.
Mm-hmm.
So, who is eligible to apply for ILR?
Well, and another generic question. I'll precisely pick up some examples, and that will candidly explain the requirements and the prerequisites for indefinite leave to remain. For example, a person in Tier 2 visa, and he is employed or she is employed in the UK for 5 years. The 5 years termination or 5 years, end of 5 years, the person can apply for indefinite leave to remain. Likewise, a spouse came from abroad because she got married to a person either who's settled in the UK or he or she has British passport.
Mm-hmm.
In that scenario, the initial grant is for 2.5 years or 3 years, which is a leave before expiry. The applicant has to apply for another extension to complete 5 years residence requirement to apply for indefinite leave to remain. Technically, he or she has to live here for a certain period of time, and he or she shouldn't be outside UK for a certain period of time. Along with that, the prerequisites, he or she has to pass English qualifications, good character, and some cases a threshold if she or he is a spouse of a British citizen. So hope I answered the question.
You did. Thank you very much. Okay. How many years do you need to stay in the UK before applying for ILR?
Well, it's a sequel of the previous question as well. It's the same thing if a person is applying for indefinite leave to remain. There's a requirement which is known as a residence requirement, and the person has to complete 5 years at the moment to apply for indefinite leave to remain. However, again, there are certain attachments with that, the prerequisites to be met, presence in the UK, good character, and more or less, if there's a spouse visa, then there's a continuity of family life. The person has to show he has been or she has been living with the spouse and there's a genuine relationship existing to apply for indefinite leave to remain.
Thank you, sir. I know there's going to be new ILR routes coming out. Would people on the ILR route that are currently on them be affected by the new rules that are coming out in April?
Well, Daniela, this is a premature, I can say, a premature answer at the moment because there are regulations yet to be formulated. Mm-hmm. It's a lengthy procedure where after the Hansards, the bills will be a part of immigration rules. So there's certain steps. First of all, we are at the very beginning at the moment, and it's premature to jump to a conclusion that those strict regulations, or the bill which has been brought in May 2025, and after the debates and hectic debates in Parliament and certain stages, whether the new bill or the new constitutional amendments will come in force this year or mid of the year or end of this year. So at the moment, it's too early to say anything about these regulations to be part of immigration rules. These are regulations yet. These are bills at the moment. And the way current government portraying those bills, they are quite strict at the moment, and they are beyond reasonable, you can say, doubts that this will be amended or that will be facing hectic challenges where I can see there are a lot of debate in Parliament, mm-hmm. because the e-petition by the people concerned, like a requirement for an e-petition to raise any kind of consultation is 100,000 people who signed the petition, and if the ceiling 100,000 petitions have been received by the Parliament, then the actual debate starts. Mm-hmm. Here in this scenario, we have more than 300,000 people who signed those petitions, and they raised their concerns about the strictness of those bills. And 2nd February 2026, the constituencies where people are concerned about their future, they have been participating on those you can say recent debate. Their MPs, certain MPs gathered in Westminster, and they started a debate here where they have asked questions about people have genuine concerns, and the immigration ministers responding those issues, and that process is still going on. So, cut the story short, I'm not sure in coming days it's premature to say or jump to the conclusion that what will be the coming future of those bills. But I could see that if those bills are not reasonable, then there'll be challenges, and I will see if knee-jerk kind of constitutional amendments have been brought in. Then there'll be clear challenges to those constitutional amendments in Strasbourg, European Convention of Human Rights or European Court of Justice will be contacted, the jurisdiction will be invoked, and those unreasonable constitutional amendments will face, in a sense, challenges, and that will be challenged definitely in the courts.
Okay, thank you, sir.